A very warm greetings. This is Shashank Mishra with the eminent senior advocate of Supreme Court of India, Subodh Markandeji. In this lecture, we will be discussing on episode Advocate on Record System of Supreme Court 50-year-old journey. Our episode 12 related on the centrality of Advocate on Record as an institutional mechanism of Supreme Court for ordinary and rapid conduct of cases. But that episode was our extempo response to the proposal of Mr. Vikas Singh, President Supreme Court Bar Association, to allow advocate with 10 years practice to act as well as plead like the AORs. You also dealt on the significant contribution made by the AOR Advocate on Records to the bar and bench. We had in that episode number 12 promised our viewers to put out a more comprehensive episode on the subject. So you can, sir, you can elaborate on that subject, sir, now.
First of all, let me correct myself for the inaccuracy of my statement. Mr. Vikas Singh did not propose abolition of AOR system, but as you pointed out, suggested that advocates with more than 10 years practice may also be allowed to act. Act, that's what's the crucial thing. Act as well as plead. But my opposition to his proposal still remains. It's as solid as it was. In episode number 12, uh, we were against the undermining the system of advocate on record because that is fraught with grave detriment to the administration of justice by the Supreme Court. So, firstly, if the proposal of Mr. Vikas Singh is accepted, then being AOR will be without any incentive. It will be very unattractive. Why will anyone, wait for four years, undergo an exacting training under an advocate on record for 1 year, then clear and examine a very strenuous examination, and then uh, get enrolled or rather registered as advocate on record with all those obligations to maintain an office within a radius of 16 kilometers of the Supreme Court, have a clerk of a particular quality, undertake, number of duties and obligations enjoined by the Supreme Court rules 2013. Secondly, and more importantly, qualitatively, advocate on record and the advocate with 10 years practice are not the same. They are totally different. So, my objection to the said proposal was and continues to be, I think, well founded.
Sir, can you please tell how did the AOR system came into the existence?
As I said in episode number 12, the Supreme Court inherited its systems from the Federal Court of India. Federal Court of India was not a court of such vast plenary powers and multiple jurisdictions as the Supreme Court of India. Those assisting the lawyers, that is barristers or whatever they were, barristers, Queen's Counsel, and other advocates in the federal court were called agents. They were not supposed to even have a law degree. Uh, I have no personal experience about that system, nor is there any published work available about that system. Fact, however, remains that the agent system was very unsatisfactory. Therefore, in 1964, the Supreme Court amended Order 4 of the Supreme Court Rules 1950 and for the first time put in place the system of advocate on record. And it has stood the test of time of 58 years. Order 4, insofar as it provides that only advocates on record will act as well as plead, was only in the nascent stage when it was challenged in Lily Isabel Thomas versus the Unknown. AIR 1964 Supreme Court 855, if I'm correct, to which reference was made in episode number 12. The challenge to Order 4 failed uh, before a four-judge bench. As of now, after 58 years, I can safely say that qualitatively, advocate on records training, experience, and other attributes cannot be matched by a lawyer with 10 years practice. Therefore, the proposal of Mr. Vikas Singh is misconceived.
So what does Order 4 of the Supreme Court rule provides?
So, when I'm speaking about Order 4, let me update myself. The Supreme Court rules 1950 were replaced by these rules of the same nomenclature twice in 1966 and 2013. Order 4 as amended in 1964 as enacted under 1966 rules and 2013 rules is substantially the same. We will discuss the latest 2013 rules, that is to say, Order 4 as it exists in 2013 rules. Order 4 of 2013 rules requires that an advocate who wants to become an advocate on record has to be enrolled by any bar council in India, and he has to have 4 years training. He alone can commence 1 year's training under an advocate on record approved by the Supreme Court of India. Thereafter, he has to pass the prescribed test, which is held by the Supreme Court twice a year under the supervision of 3 judges of the Supreme Court. Now, as per the regulations framed in the Supreme Court rules in that behalf, the test consists of 4 papers, namely practice and procedure, drafting, advocacy and professional ethics, and leading cases. The candidates have to obtain minimum 60% marks in aggregate and minimum 50% in each paper. Needless to say that the standard of examination is pretty high. After passing the test, an advocate is registered by the judge in chambers as an advocate on record. He has to employ a registered clerk of certain caliber and attributes and have a registered office within the radius of 16 kilometers of the Supreme Court of India. He has to maintain the usual books of record as are done by solicitors. So he is under a strict code of discipline as advocate on record. By reason of their training and practice, advocates on record become very thorough with the record of their cases which they handle. They also become quite thorough with the law involved and the judicial precedents bearing on their cases. So they are of, I would say, abiding value to the not only to the leading cases but also to the court.
So you had promised to give more up to date about the contribution of AORs to the bar and bench.
Yes, so the list is very impressive. The present Chief Justice of India, Justice Uday Umesh Lalit, started his practice as an advocate in the Supreme Court of India as an advocate on record, and later was designated as senior advocate and then elevated to the Supreme Court bench itself directly from the Supreme Court bar. Justice Sindhu Malhotra also started her practice as advocate on record. She also became the senior advocate and was elevated to the Supreme Court bench directly from the Supreme Court Bar. Justices S.C. Agarwal, Dalbir Bhandari, now a judge of the International Court of Justice at Hague, uh, Justice B.P. Singh, Gyan Sudha Mishra, B.S. Chauhan, Madan Lokur, and Ravindra Bhatt all started their legal practice in the Supreme Court as advocates on record. Uh, they were raised to the bench of various high courts in India and then were appointed as judges of the Supreme Court. Now the AORs who become the judges of the Supreme Court, no, judges of the High Court, I'm sorry. Judges of the High Court are too many to enumerate also in a format like this
Yes,
because
sir.
they are so huge in number. To the bar, the Advocate on Records have contributed the present Attorney General of India, Mr. R. Venkatramani, and his mentor P. Parmeshwar Rao, who also started as advocate on record, became a senior advocate, and practiced with great distinction. Presently, I think at least one-fourth of the senior advocates designated by the Supreme Court are from their own bar. That is, they are not from retired judges because in our Supreme Court, senior advocates are uh, either from the Supreme Court bar, that is AORs and others, or the retired judges of the High Court. So, as I said, uh, I think estimate is rough, but one-fourth of the senior advocates designated in the Supreme Court at present are from the ranks of uh, advocate on record. So this is a great contribution made by the ranks of advocates on record. They are of enduring value to the Supreme Court. And it's not correct to say that others should also be allowed to act. So that's the take.
Sure, sir. We agree on your point, sir. And with that, we will extension of the episode number 12 is now here. Thank you, sir, for being present and telling us about it. That's all for the day, sir.
Thank you.